Leading our bulletin this hour, the Electoral Court has reserved judgment in the matter concerning the Umkhonto weSizwe party. It's appealing the Independent Electoral Commission's decision to uphold objections to former President Jacob Zuma standing for public office. The court will hand down its order tomorrow. MK Party's advocate Dali Mpofu says disqualifying Zuma from the polls is a violation of his rights. Now, Mpofu has warned that Zuma's rights set out in Section 19 of the Constitution would be infringed if he was declared ineligible to stand for public office. The party is appealing the Electoral Commission's decision to uphold Jacob Zuma's name on its candidate list. The IEC announced that Zuma was ineligible to stand in elections as per Section 47, subsection 1E of the Constitution. The section also regulates membership of the National Assembly.
Let's stay with this particular story now and speak to my colleague Canny Maphanga, SABC News Reporter, who's been watching this story for us in court. Kenny, of course, a big day in court today, but interestingly, the interpretation of Section 47 of the Constitution coming into sharp focus.
Indeed, evening to you, Bongiwe, and to the viewers at home. Of course, at the center of this issue is how do we interpret Section 47, subsection 1E of the Constitution, which guides how you become or you get disqualified as a member of the National Assembly. Now, the said section states that if you are convicted and sentenced to 12 months or more without the option of a fine, then of course you're not eligible to stand for the National Assembly. Of course, then that doesn't end there. After you've completed your sentence, there's another 5 years in which you're disqualified before you could even get to that court. So if we just summarize quickly what each party has said, is that the former president's counsel have argued that it actually doesn't apply rather to the former president because they're stating that there wasn't a conviction. Remember, he has a constitutional court order for the contempt of court that was in 2021. That was in civil proceedings. They're arguing that because it wasn't in criminal proceedings, that it doesn't apply to the former president because you need to appear rather before a judge, get criminally charged, go through a trial, which is all part of your constitutional rights. But of course, the IEC is stating that that is a plainly absurd interpretation of how to follow these proceedings. A contempt of court is a contempt of court, whether it was delivered by the civil court or the criminal court is still a conviction, and the president was given that conviction. So he is a quote-unquote convict. Then, of course, they'll speak of the remission of sentence. Now, you remember he was a beneficiary of that remission of sentence, which meant in totality that he had about 3 months that he had served instead of the 15 months handed to him by the Constitutional Court. Now, what his lawyers have said is that you end at the 3 months. You don't then go and count the 15 months, which is now short of the yardstick of the 12 months, which you need for that legislation to apply. But the counsel for the IEC is stating that the sentence is the sentence no matter what executive decision is taken. So there may be a remission that is granted in order to deal with the issue of overcrowding, but the sentence is the sentence nonetheless, and is asking the court to dismiss that appeal on that basis alone.
And you also then, I mean, when you listen to Advocate Thembeka, for example, saying that the court should not be concerned about the 3 months, but be concerned about the 15 months, which is an order that was handed down by the Constitutional Court. But interestingly also, the powers of the IEC coming into sharp focus here as well, because the lawyers for the former president arguing, saying that the IEC's powers are limited to managing elections and emphasizing the importance of the separation of powers for them. And they're also saying that the National Assembly holds the prerogative to determine membership eligibility. And what did the IEC have to say to this?
Well, you're quite correct. The counsel for the former president is stating that they exceeded their powers and their limitations in their jurisdiction by even answering this question, saying that the question itself resides with the National Assembly. But of course, the bigger argument for Advocate Rather Ngugaitobi is that you have to look at the legislation in the form of its purpose. So what is the legislation trying to do? It's trying to exclude lawbreakers from entering into a space where there are lawmakers. So against that backdrop is which you judge how to determine this issue of whether the Section 47, subsection 1E of the Constitution applies to the former president or not. And the IEC is of the view that they interpreted it correctly and that there was a sentence, there was a conviction, and that disqualification does exist.
Quite an interesting one. And also, even the IEC also then not escaping scrutiny here, as we heard from the lawyers as well, saying that what their Commissioner Janet Love had to say in a press briefing also for them, and that's the former President Jacob Zuma's lawyers, saying that for them it displays some bias.
Well, this was an argument that was raised by the counsel for the former president, and it deals with this question of bias. So they're saying there was a January 2024 media report in which Janet Love, one of the commissioners, is quoted as speaking on or making a statement on this issue of the eligibility of the former president. And the counsel is saying that that specific statement didn't have to do with candidates as a whole. It was very specific to this individual. And they're saying because she had already announced or said in a statement that he was ineligible to stand due to that criminal conviction, that they had already prejudged prematurely the issue. So when an objection did come to them in March, the appropriate thing to have done by the commissioner would have been to recuse themselves from this decision based on what they've said already. You've heard that from the counsel as well, that Judge Pillay recused herself from that decision as well because she sat in the Constitutional Court hearing, which made that contempt of court finding. So they're saying on that basis alone, there was questionable bias and she should have excluded herself or recused herself from that decision-making process, which we saw on the 28th of March, where they decided to uphold that objection. But of course, the IEC is qualifying that by listing the context in which that statement was made, and that she was answering a question from the media regarding the eligibility of the candidates and answering the legal question as to who can stand and what bars you from standing as a candidate in those candidate lists.
So can you then talk to us about what happens now in terms of the process, especially when you think about, some of the matters that have now appeared before the Electoral Court? So what becomes the next step?
Well, according to the election timetable, the deadline for the appeals is tomorrow. Once that election timetable is gazetted, I don't think the court has the powers to change that timetable. So they really are under a tight deadline, and we are expecting that an order will be electronically delivered at least by 2 p.m. tomorrow, and we can see what that order states, and then we can take it forward from then.
All right, quite a busy day for you then, I suppose, tomorrow. But thank you so much, Canny, for bringing us up to speed there. That's my colleague, Canny Maphanga, who was tracking those developments in that case between the IEC and the MK party. And we'll bring you the ruling as soon as it comes out.